A very good day. Allow me to extend a very warm welcome to our speakers and to all participants who have registered for this webinar. I am Cyrus Das. I am the moderator for today's webinar, and I am moderating from my home jurisdiction, Malaysia. I am very pleased to say that we have over 300 registered participants from 40 over jurisdictions. And this is the third webinar in a series on constitutions and the rule of law, which has been organized jointly by Law Asia, the Commonwealth Lawyers Association, the South Pacific Lawyers Association, and the Law Council of Australia. It is in many ways an inaugural series, and I'm pleased to say that the previous two webinars have been tremendous successes. Today's webinar is on the topic of constitutional breakdowns, coups and emergencies. We have a distinguished panel of 5 speakers, whom I will introduce very briefly before I call on them to speak. But to let you know that their speaker profiles are found in the webinar website. And we are going to move rather swiftly today because we have just 1.5 hours for this webinar session. And the first hour will be taken more or less by the speakers, who will each be given about 10 minutes to address the topic that they'll be speaking on. And the reason for that is this, that we have a large number of interest shown on the topic, and therefore we have a large number of pre-submitted questions. And it is important, pursuant to my discussion with the panelists, that we try as far as possible to answer all the questions that have been submitted. So we are allotting half an hour in this program to take on these questions. And it might not be possible for the speakers to answer each and every question that is posed, because many of them come as sub-questions. So they will be picking up the themes that are being posed under the questions and address them. And without further ado, so that we could keep time efficiently, I think we will start, and I think it is appropriate that we start with Myanmar, which recently suffered a military coup. And it gives me great pleasure in this respect to invite Professor Melissa Crouch from the University of New South Wales to address us. Professor Melissa.
Thank you, and thank you for the opportunity to be part of this seminar, and to the organisers for hosting such an event on an important and timely topic. I want to, in my brief time, explain what has happened in Myanmar from a legal perspective, why the military took over, and what some of the legal issues are, and in particular why it matters whether we call it a coup or a constitutional state of emergency. In short, the military at the moment is claiming that this is a constitutional state of emergency. That is hotly contested and disputed by those who are opposing the military regime. As many of you might know, last year on the November 2020, Myanmar held a national election. At that election, the National League for Democracy, which is Aung San Suu Kyi's political party, was successful in obtaining an overwhelming majority of the votes. The military was unhappy with this outcome and began to dispute the electoral voter list in particular, and claiming that there was fraud. The military tried various means to raise their complaints. They went to the Union Election Commission, but were not satisfied with the answer there. They went to Parliament and tried to seek a special session of the joint sitting of the Parliament, but that was declined by the Speaker and the President. And they also went to the Supreme Court. They actually, a week prior to the coup, they sought, had an application for writs of quo warranto and mandamus against the Union Election Commissioners themselves, as well as others such as the President. That case was never actually heard because on February 1, all the incoming elected members of Parliament had gathered in Naypyidaw and were anticipating taking office. Instead, the military had other plans. Early on the morning of 1st of February, they took over. They did so by first arresting the president and Aung San Suu Kyi, as well as some other high-level government officials. And then since then, things have quickly escalated. It's important to note that the legal basis that the military claims for its actions is illegitimate, really, and unconstitutional. So the military claims that because the president failed to take action regarding the allegations of electoral fraud, that therefore the president was able to be arrested and was no longer in office, and that the vice president, who happened to be a former military officer and supports the military, has taken over as president. And then in that capacity, the vice president, who became acting president, exercised a provision in the Constitution concerning emergency powers. However, there's quite a number of flaws in that logic, including the fact that the president is required to consult with the National Defence and Security Council. Now, according to the Constitution, the National Defence and Security Council is composed of both civilian members of Parliament, such as the President, the Minister for Foreign Affairs, the Speakers of the Houses, as well as some military members. However, clearly that wasn't possible on the 1st of February because many of those civilian members were actually already arrested. And so it's not possible for the military to claim that they lawfully exercised the constitutional emergency powers. So just in brief, what's happened since then? There have, of course, been massive protests in Myanmar, and we've seen this right across the country in pretty much every township. This has been a vibrant and creative response. There has been a high level of youth participation, particularly with Gen Z. And really a cross-section of people, from people who work in banks who are going on strike to try and cripple the financial sector, to civil servants in Naypyidaw protesting in what's really quite an unexpected show of support or show of opposition to the military takeover. So in brief, what happens from here? The military on its side is claiming it will be in power for 1 year, and then after that time it will potentially hold new elections to form a new government. That, of course, is hotly disputed, particularly by the NLD. And there is an organization called the CRPH, the Committee for Representatives of the Pirang Suluto, or basically the incoming elected members of government, who have effectively formed an opposition organization and are claiming that they should have power transferred to them. But of course, then there are a range of demands. And one of note is in particular various minority and ethnic groups that have very often called for a federal system, and who see this as a potential opportunity to rewrite the constitutional rules, if you like, and to try and transfer perhaps to a different system entirely. The chances of that, I think, are quite slim. The military has clearly shown that it is willing to use violence and in quite a chilling and calculated way. And so we're seeing the death tolls at protests rising quite significantly. And so in coming days and weeks, I think we're going to see more of this. The military has also been willing to amend key aspects of the law, including things like adding offences to the penal code to particularly prohibit any sort of disturbance to the defence services or insults or other accusations, I guess, against the defence services as a way of trying to protect itself at this time. We're seeing night raids. There have been amendments to the law restricting privacy, as well as a potential cybersecurity law that appears to mirror developments in China and possibilities that maybe Myanmar is developing some sort of firewall, or that it will enact this proposed cybersecurity law which would radically give it radical powers to really control how people use the internet and access to people's data. So I'll leave it there just to conclude by saying that I think this is clearly a coup and not a constitutional state of emergency. I think this matters because it's the way in which the military is trying to claim legitimacy for what is otherwise an illegal set of actions and situation. And we very much need those both at the international level, but at the regional level, to be supporting people in Myanmar at this time, including its legal profession. Thank you.
Thank you very much, Professor Crouch, for that very succinct and clear analysis in the short time that you had of the legal status now that is prevailing in Myanmar, and the real legal status of what has happened, that it is a coup and not a constitutional change, so to speak. Our next speaker, without further ado, our next speaker is Mr. Andrew Coups, who is the co-chairman of the Human Rights Committee of the Malaysian Bar Council. Andrew is a very strong advocate of human rights within my jurisdiction, and I invite him now to speak of the Malaysian emergency, which was declared to handle the COVID crisis in January of this year. Andrew, please.
Thank you, Dr. Cyrus, and greetings to all the participants. By way of a brief introduction and background, back in October of last year, the current Prime Minister of Malaysia had basically articulated an intention to possibly declare a state of emergency, or to at least advise on the declaration of a state of emergency in response to the increasing deteriorating situation of COVID-19 in Malaysia. He went as far as to seek an audience with our Yang di-Pertuan Agong, the King, who declined the request to grant a proclamation of emergency. And the contemporary stories at that time was also the fact that there was an attempt perhaps to scuttle the government, to defeat it by way of a vote of no confidence in an upcoming budget debate in Parliament. And so at that time, it was already linked this idea of a declaration of emergency and a bid to stave off a possible vote of no confidence. So when the king decided not to grant the declaration of emergency, life went on until in January this year, when on the 12th of January, the Prime Minister again went on public national TV and basically announced that the king had granted a request to declare, to make a proclamation of emergency with effect from the 11th of January until the 1st of August. And again, the raison d'etre, the rationale for that proclamation was the continuing deterioration in the COVID-19 situation. And then a few days later, on the 14th of January, we had published in the Government Gazette the Emergency Essential Powers Ordinance, which basically sets out the rules, in a sense, the rules by which the emergency would be effected. And so if you look at that particular document, and I'll spend a little bit of time focusing on that, you can see that it's been divided into basically 5 aspects. There's an aspect that deals with the health situation itself, another aspect dealing with the logistics of assisting in supporting the health pandemic. There is a section that deals with security, in other words, powers of the police, and also the powers of police being extended to the armed forces. There is a section on compensation and indemnities for the actions of the executive. And then lastly, there is a section that deals with the law and the constitution. Now, having said that, I would like to comment on this by making 3 points, which I think is relevant for our discussion this afternoon. One is the use of the constitutional provisions to declare a so-called emergency. So like very much what Professor Crouch said earlier, both I think the constitution in Myanmar and the constitution in Malaysia does provide for the possibility in the constitution, the possibility for the declaration or the proclamation of a state of emergency given a certain threat to national security. So the question, of course, then that must be asked is whether or not the prevailing circumstances justify an escalation to that level for a proclamation of emergency. And in Malaysia, of course, it was the health pandemic that was articulated by the government as being the ultimate concern. But we still cannot run away from the linkage that this proclamation has, and I'll come to it in a short while, about the effect that it supersedes really all the other provisions of the Constitution. So what in fact happens is that in a declaration of emergency, Parliament can be suspended, but in the case of Malaysia, it was not suspended because Parliament was not yet sitting. So Parliament will not be recalled, and the respective state legislative assemblies also will not be recalled until at least after the 1st of August. And in its place, the government, the executive, can, in the name of the king, promulgate emergency ordinances. And the Constitution provides that these ordinances may well contravene the existing provisions of the Constitution. So you can see a putting aside of fundamental liberties, putting aside of electoral rules about the functioning of Parliament. So I think, as I suggested in my title, this is arriving at a political ends using constitutional means. And so, as I've already said, consequently, the power to govern is now held very closely, and this is my second point, by the executive itself, without any ability for a check and balance mechanism from Parliament. Now, the third point would be the fact that you have to look at the role of the courts. And now, again, resorting back to the Constitution, what you have are provisions which were inserted under previous amendments to the Constitution that basically say that laws and ordinances promulgated under this proclamation of emergency cannot be challenged in a court of law. So although the courts continue to function, their remit is now limited by the fact that there is, in effect, an ouster clause to the effect that you cannot bring laws of this nature for judicial review by the courts. So perhaps in some cases in other countries, maybe in Myanmar, for example, as I understand it, the courts are simply closed down, or the existing judges resign and fresh judges are appointed. Obviously, those who are perhaps more inclined to support the ruling military junta. But in Malaysia, it's almost a self-censorship in the sense that the judges, if they are constitutional literalists or legal literalists, basically obey the letter of the law and say, look, if the Constitution says we can't challenge it, then we are not going to allow it to be challenged. And that, of course, raises the question about the fundamental role of the courts in a situation of a declaration of emergency, and also this whole concept of a separation of powers and a basic structure of the Constitution doctrine, and what happens to that in a proclamation of emergency. Can the courts actually review a declaration of emergency when it is alleged it may be colored by corollary purposes? So I think that's really where I would put things at the moment, just by way of a background to Malaysia. And I've hoped that I've set out some of the more overriding issues that may be relevant in a cross-country analysis of this question that we can then discuss later on and take questions on. So thank you very much, Dr. Cyrus. I yield back the space to you. Thank you.
Thank you very much, Andrew. Thank you for that very clear analysis of how an emergency was declared in Malaysia within the terms of the Constitution and the effect of the emergency legislation, which you say is overriding with an embedded ouster clause, and the effect of that. I think if there's any interest in that area, I'm sure you'll take it up at question time. But allow me to move on in terms of efficiency of time keeping to our next speaker. Our next speaker is Mr. Graham Leung, former president of the Fiji Law Society, a well-known figure in Law Asia circles. And Graham is going to speak on the Fiji experience of coups and courts. And allow me to welcome Graham onto the panel, or onto the podium to speak to us. Graham, the floor is yours, please. We are not hearing you, Graham.
Thank you, Chair. Can you now hear me?
Yes, I can hear you now. Please go ahead.
Can I suggest, Chair, that you move me one speaker because I have lost the screen of speakers. So let me try and get back on. And in the meantime, I don't want to waste the panel's time.
Yes, all right. Thank you, Graham. I will shift the order then. And
just
bring
by
you
one
back.
speaker.
Yes, and bring you back as soon as you're ready.
Yes,
so,
thank
do indicate to us in some means when you're ready.
Will.
All right.
Thank you, Chair.
Let me then move on to Dr. Jayampathy Vikramaratne, who will speak to us about the Sri Lanka experience. Dr. Jayampathy is senior counsel practicing in Sri Lanka, a former member of parliament, a constitutional lawyer, and the topic that he's going to speak to us is on, quote unquote, the failed constitutional coup in Sri Lanka 2018. Dr. Jayampathy.
Thank you, Chair, and thank you, the organizers, for this opportunity. I wonder whether you can see my screen fully. Sri Lanka inherited a parliamentary form of government from the British in 1948, but in 1978, a presidential form of government was introduced. The president and parliament would go on for 6 years, and the president would have the power to dissolve parliament at any time after 1 year, and even within the first year if the previous parliament ran its full term of 6 years. And the president would appoint the prime minister. Of course, there was the provision that the member of parliament, the prime minister, would be the member of parliament who, in his opinion, is most likely to command the confidence of parliament. But there was a contradiction in terms in that the constitution also permitted the president to remove the prime minister at any time. The president, of course, also had near total immunity from suit. Parliament also had the power to remove the prime minister. That is, if the prime minister loses his majority on the floor of the House, either the statement of government policy is rejected, or the budget is defeated, or a vote of no confidence is passed. And then the prime minister is deemed to have resigned, and the president would then appoint a new prime minister and a new set of ministers. Now, this was changed in 2015, during the time I was involved in this, in drafting the 19th Amendment, I must say, that, and the president's powers were reduced, and we shifted from a presidential form of government to a mixed system. The president's powers were reduced, the terms of the president and parliament were reduced. And the president's power to dissolve parliament was restricted. He could not now dissolve parliament for 4.5 years unless parliament would request by a 2/3 majority. The cabinet of ministers would be appointed by the president on the prime minister's advice. And the president's power to remove the prime minister was deleted from the constitution. So the removal of the prime minister became essentially a power of parliament in the three instances I dealt with earlier. And the president's official actions would be subject to judicial review by fundamental rights application. And this is important. The Constitutional Council was reintroduced. We have a Constitutional Council and approval of the Constitutional Council is needed for appointments to the superior courts. And that strengthened the judicial independence. Now, in 2016, in September 2016, by that time, the relations between the President Sirisena, and Prime Minister Wickremesinghe had broken down, deteriorated. And on the 26th, the President removed the Prime Minister. And the former President Rajapaksa, who was defeated by President Sirisena at the previous election, was appointed Prime Minister. Now, the President claimed that because he was the appointing authority, he could also remove the Prime Minister. Mr. Wickremesinghe, who was removed, I think wisely decided at that time not to challenge the removal in court, but to concentrate on safeguarding the parliamentary majority. Because his position was, even if he succeed in court, if he lose the majority in parliament, what is the point? So the energy, we concentrated on safeguarding the parliamentary majority, and we were able to do that. President Sirisena is expected to, I'm told that he was expecting 13 or 14 people, members of parliament, to cross over, but that did not happen. So frustrated by the lack of a majority in parliament, then he purported to dissolve parliament. Now this was in the third year of parliament. He couldn't have done it, but he claimed that he had plenary power to dissolve parliament, even before 4.5 years had passed. This happened on a Friday, and by Monday morning we went to court, and the Supreme Court granted a stay of dissolution of parliament, and parliament met. And when parliament met 2 days later, the new government within courts of Rajapaksa was defeated in parliament. Not once, but number of times during that 2-3 weeks. It was defeated number of times in parliament. And on the first day, it was very interesting. The speaker first addressed Mr. Rajapaksa as prime minister because he had been appointed, although unconstitutionally, as prime minister. And the moment Mr. Rajapaksa was defeated on the floor of the house, he referred to Mr. Rajapaksa as Honorable Rajapaksa, not referring to him as prime minister. So you had the president, the speaker, recognizing that the prime minister has gone out of office. But he wouldn't budge, and the president continued to recognize Rajapaksa. And 122 out of the 225 MPs went to the Court of Appeal and obtained, we applied for a quo warranto and obtained an interim order restraining Mr. Rajapaksa and his ministers from functioning. And then the Supreme Court went into the main claim, the main issue, the power of dissolution. Now, President said, I have plenary power to dissolve because it is listed in the enumeration of my powers. So although later it says I could dissolve parliament only after 4.5 years, because I have this plenary power, I could dissolve parliament. Now, fortunately for the country, the Supreme Court rejected it and said, you don't have such plenary power. It is very clear that you can dissolve parliament only after 4.5 years. So dissolution was now struck down by the Supreme Court. Mr. Rajapaksa, in the meantime, went to the Supreme Court obtain leave against the interim order of the Court of Appeal, but the Supreme Court refused to give a stay. And then he resigned. I mean, he purported to resign. Our position, of course, was that he need not resign because he had already lost office by being defeated in Parliament. The President refused to reappoint Mr. Wickremesinghe, but finally had to give in after some time. So for 52 days, we had this constitutional coup. Number of issues arise. Now, when listing powers, this would, for many of you, it will sound obvious, but when listing powers of an authority to use, for example, in this case, the power to dissolve Parliament, should you always say subject to the provisions of the Constitution. Argument was that it doesn't say subject to the provisions of the Constitution, therefore I have plenary power. Fortunately, the Supreme Court said no, even in the absence of such a phrase, you don't have that power. Now, the judicial challenge was, we succeeded because of the independence of the judiciary. It had been strengthened by the 19th Amendment. That is the point that I wish to make. So all this was possible because the judiciary was independent. Now, unfortunately, the government has changed now since in 2015, and most of the gains of the 19th Amendment have been reversed by the 20th Amendment to the Constitution. So we are back to a presidential form of government. And when the 20th Amendment was brought before Parliament, we only have we have pre-enactment judicial review. We don't have post-enactment judicial review. So when the bill was challenged, unfortunately, the Supreme Court said that going back to the 19th Amendment would not necessarily affect the sovereignty of the people, and therefore did not require approval of the people at a referendum. So the 20th Amendment was passed, but some clauses were struck down. For example, total immunity from suit of the president was not allowed. So to that extent, some of the gains of the 19th Amendment have survived. Those are the matters that I wanted to place before you. Thank you very much for this opportunity.
Thank you very much, Dr. Jayampathy. That was a very impressive account within 10 minutes of the events that have taken place in Sri Lanka in 2018 and 2019. Your presidential system and the active role played by the courts and the demonstration of the independence of the judiciary, and now the impact of the 20th Amendment, which you say reverses much of the 19th Amendment. If there's any follow-up on that from our participants who have logged in, I suppose they may pose questions on that. But allow me to move on in terms of time efficiency. Graham, are you all right?
Yes, I'm just unmuting. Can you hear me?
I can hear you.
Okay, I'm now ready to make my presentation.
Yes, I've already introduced you.
Yes, thank you very much, Chair,
yes,
co-panelists, as well as participants listening in to this webinar. The topic of my presentation today is of coups and courts, the Fiji Experience. Now, Fiji has, since 1970, its independence, we have had a number of coups and a number of extra constitutional usurpations of authority. As a result of that, we first started out with the 1970 Constitution. And subsequent to that, our first coup was in 1987. Then we followed that with the 1990 Constitution. And in the year 2000, we had another attempted coup by a civilian by the name of George Speight. Following that, we had the 1997 Constitution, and then eventually our current Constitution. When that 1997 Constitution was abrogated, we now have a 2013 Constitution. So just to put things in a historical perspective, we've had 3 prime ministers deposed or removed over the last 50 years. And we have had the 1970, the 1990, the 1997, and the 2000 Constitution. So 4 constitutions over 50 years, 3 democratic prime ministers removed. So we've had a somewhat checkered experience with the courts, and the courts in Fiji have struggled with having to deal with extra constitutional usurpations of lawful authority. A number of cases have emerged in that period. The main cases I refer to in this webinar are Chandrika Prasad, Garase, and the Yambaki cases. And in all those different cases that were litigated in the domestic courts in Fiji, the Fijian courts referred to a number of authorities in Uganda, in Pakistan, a House of Lords decision, as well as the famous Mitchell case, which was a decision of the courts of Grenada. So basically, in the Chandrika case, which was a year 2000 decision of the, first of all, at first instance, in the High Court of Fiji, Justice Gates, as he was then, before he became Chief Justice much later, he made the observation that a constitution, being a written document and the supreme law, is indestructible. And he said in that Chandrika case, it is not possible for a man or any man to tear up the constitution. And he has no authority to do so. So the Court of Appeal basically affirmed the decision of the High Court, and it declared the purported removal of that constitution was unlawful and without validity. And in the Court of Appeal, they referred to the seminal principles that were drawn from the case of Mitchell against the Director of Public Prosecutions. You would have heard of that case. So there are basically 4 principles when the doctrine of necessity may be concluded to apply. There must be obviously an imperative necessity. There must be exceptional circumstances not provided for or contemplated within the Constitution, giving rise to a unique set of emergency situations that require the vital functions of the state to be preserved and supported. There must be no other reasonable course of action, and the action taken must be necessary for the peace, order, and good governance of the state. And finally, the citizens' rights must not be impaired. So that was the Chandrika case. It basically was described as the case that stopped a coup. But unfortunately, in Fiji's history, we had other coups and other extra constitutional usurpations by usurpers. The Prime Minister Chaudhry was removed in the 2000 coup, and the case of Yambaki was subsequently litigated. Unfortunately, Mr. Chaudhry was not able to come back. But again, in the Yambaki case, the court struggled. On the one hand, you've got legal principles with respect to the interpretation and application of the doctrine of necessity. But in the Yambaki case, Justice Scott had to grapple with the political realities that events had moved on and had overtaken the removal of the Prime Minister. And then finally, in the Garase case, which was a decision at first instance of the High Court and eventually in the Court of Appeal, the 5 judges of the Court of Appeal found that the assumption of executive authority by the head of the military then was unlawful. And they also found that the dissolution of parliament was unlawful. So the courts in Fiji have, depending on the High Court or the Court of Appeal, there's been a certain ambivalence, a certain, if you like, recognition of political pragmatism, that when events unfold on the ground, when there's been a large measure of acquiescence by the people, when there has been little evidence of robust opposition by way of protests and demonstrations, the courts have been in a predicament, if I can say so, of on the one hand applying the formal legal principles with regard to recognition of governments when there's been a revolution, if you like, and then dealing with the political realities on the ground, and really having to undertake a fine balance when the courts might perhaps have to deal with situations of instability that could lead to anarchy. So the courts in Fiji have concluded that where there's been a revolution or attempt at removing or upsetting the established legal authority, the burden of proving that the revolution has succeeded is on the de facto government seeking to maintain control and establish itself. The other principle that's worth bearing in mind is if there's an alternate government in the waiting, the courts are cognizant of that and would take that into account. And the other issue that I wish to mention is that in the case of Republic of Fiji against Chandrika Prasad, which I had mentioned earlier, a full bench of the Court of Appeal quoted with approval Lord Pierce in the case of Madsim Mabuto. And again, many of you on this panel would have heard of that case. And I just want to refer briefly to a dicta of Lord Pierce in that decision of, I think it was the House of Lords, at page 732, where his lordship said, and I quote, "I accept the existence of the principle that acts done by those actually in control without lawful validity may be recognized as valid or acted upon by the courts with certain limitations, namely, 1, so far as they are directed to and reasonably required for the orderly running of the state, and 2, so far as they do not impair the rights of citizens under the lawful constitution, and 3, so far as they are not intended to and do not, in fact, directly help the usurpation." And then the Court of Appeal said, "We respectfully adopt this statement as an expression of the law applicable to Fiji." So that it shows in some of the cases that I have sought to draw out, the courts in Fiji have, on the one hand, been aware of a range of decisions from around the Commonwealth with regard to post-revolution regimes, the complexities of recognition, despite clear legal principles about when a revolution is deemed to have succeeded, but then overtaken by realities of populations that have acquiesced, writs of elections that have been produced. And I can see your hand has risen, Chair. And then, so I just wish to conclude by saying that, yes, it is a very complex area. and the courts really are limited, because as has been said in the past, the courts have neither the purse nor the sword to enforce their judgments. They can make declarations as to legality or illegality, but in the end, if you have usurpers that are determined to ignore the orders of the courts can do no more. Thank you very much for your patience.
Thank you very much, Graham, for that very comprehensive account of the case law in Fiji and how it has moved on. And as you put it very correctly, elegantly, the checkered experience of both government and the judiciary in Fiji, the dilemma of the courts, and so on and so forth. But the body of case law on extra-constitutional measures and coups from Fiji is truly impressive. Let us now move on to hear Professor John Hatchet, Emeritus Professor of the University of Buckingham in UK. And John has got a long history of his own in serving the Commonwealth Lawyers Association, of which I'm very closely associated as the honorary president. And I've known John for more than 30 years, and he doesn't seem to be slowing down in any way, although he's called Emeritus Professor now. But John is going to speak to us on the very interesting topic of, quote unquote, undermining the Constitution by constitutional means. How is that done? We'll hear John now. Professor John Hatchet.
Thank you very much, Chair. Is it really 30 years? It doesn't seem like that, but anyway. I've been very interested in the previous speakers as well, because in a sense, the discussion on constitutional amendments and the use of emergency powers also brings into the context I want to look at, which is undermining constitutions by constitutional means. And I wanted to then, first of all, start with a very basic idea of what is a constitution. And this is my favorite description of a constitution from the great South African judge, Ismail Mohammed, where he speaks of the constitution being a mirror reflecting the national soul, and goes on to talk about it being the articulation of the values of its people and disciplining its government. And what I've always been very interested in, and I may be a bit difficult on this, is to explore the extent to which a government can undermine a constitution by constitutional means. And this is what I wanted to just talk about today, using the presidential power of pardon as an example. Now, in general, we look to the presidential power of pardon as being what I would call the constitutional gift of benevolence. It allows then for a relief from a harshness or from a mistake in the operation of the criminal law. And it's thought best to vest some other authority than the courts to make that particular judgment. No problem, I think, on that. Constitutions almost invariably then place the power of pardon in the president. The US Constitution, in fact, the Myanmar Constitution, and Commonwealth constitutions, again, have this power. What's very interesting about these constitutions, many of them, are that the power of the president is the same as that of the colonial governors. There's really been very little thought about how to construct the power of pardon in a constitutional setting. And as you can see here, the president may grant any person convicted of an offence a pardon. And also of great interest to us today, I think, to remit the whole or part of any punishment or any penalty or forfeiture. So that's fine. The problem to me comes when the power is used to undermine the Constitution with politically motivated pardons. And this situation arises particularly when PEPs, politically exposed persons, are given a pardon, and potentially this is, say, an instrument of abuse, because it undermines fundamental pillars of the Constitution and undermines the rule of law, particularly when the work of the courts, judiciary, is nullified by the improper exercise of that power. So you've got the problem, as I call it, of PEPs. And it's a conundrum. It's a conundrum because if we look at this situation, the president of Utopia, any country, pardons a PEP who was convicted of a corruption offence and sentenced to imprisonment and forfeiture of their assets. Now we have good guy, bad guy scenario. The good guy scenario is one where the conviction itself was politically motivated. The bad guy scenario is where the PEP was rightly convicted following a free and fair trial, but is a supporter of the president. So how do you actually deal with pardons when you've got this conundrum? And that also leads to the second point and our third scenario, which is following a pardon, does the PEP or is the PEP allowed to return to public life? And also, of course, to recover their assets, which have been previously forfeited. So what are the constitutional safeguards? Well, in some constitutions, there is no constitutional check. The United States Constitution, of course, being a clear model there. Many constitutions in the Commonwealth have adopted this advisory committee model. Again, a model which is based on the old colonial regime. And this is a limited effect safeguard, if you like, because it raises issues, and this varies from country to country, jurisdiction to jurisdiction. What powers does the advisory committee have? Can it recommend a pardon? Can it simply agree to a pardon, advise the president? Can it veto a presidential pardon? And that, of course, then raises issues like its independence, are reasons required to be provided, and how transparent is the process. So there is a problem, I think, in terms of safeguarding the application of the power of pardon. Judicial review, we've talked a little bit about that this morning. It seems to me that there is a possibility of a review of the pardoning power. There's authorities from India on that. And of course, many of you will be aware of the Vanuatu experience, which I haven't got time to go into now, but actually raises to sort of other points relating to the question of whether the president can pardon herself or himself, which was done in the Vanuatu situation, and whether a president can actually revoke a pardon. And I'll leave that to one side for the moment. So we've got a situation where the Constitution has some safeguards on the actual implementation and granting of the pardon. What's the impact of a pardon on pets? Now, one argument is that it wipes the slate clean. In other words, there is no criminal conviction, the individual is allowed to return to public life and perhaps to recover the forfeited property. And here we have the good guy, bad guy scenario kicking in again, because if it's a good guy scenario where the conviction was politically motivated, then surely we want to allow that person back into public life and to set wipe the slate clean. Whereas if you have a bad guy scenario, that's exactly what we don't want to do. So there is a problem again there in terms of how we deal with the impacts of a pardon. So overall, my argument is that we need to review and develop effective, independent and transparent review mechanisms. I've given a few ideas there, a review committee with teeth, giving the legislature a role to review or to reverse the presidential pardon, the importance of judicial review, and as some new constitutions have, the constitutional right to fair administrative action. And it seems to me that this is an area, like others, where a constitution can be undermined by constitutional means. So I'll leave it there. Simply, this is not really a publicity stunt, but I have a new book out, Combating Money Laundering in Africa, which has a full chapter on dealing with pardons, and also another range of issues where PEPs can undermine constitutions by constitutional means. So I notice I am 10 seconds over my allotted time here. So I will immediately stop and hand over to you. Thank you very much.
Thank you very much. Thank you very much, Professor John Hatchet. That was a very interesting account of, again, we are back to this question of presidential powers, the scope of it. And you spoke at length about the presidential power of pardons and this new doctrine, I think, that I've heard now of politically exposed persons, the doctrine of PEPs. And well, there you have it. And may I, before I move on to taking on the pre-submitted questions, rather prematurely, congratulate all our speakers, because we are within the hour, and tremendous discipline exercised by all the speakers, leaving us with exactly 35 minutes, so to speak, for questions. What we intend to do is this. We have had a large number of pre-submitted questions coming from more than 12 jurisdictions. And yesterday, in the pre-session discussions with the panelists, we decided that we will try to group them together on the basis of themes rather than jurisdictions. So I will just give the jurisdiction from which the question comes without giving the names. But otherwise, they are being assigned on the basis of the themes that they have sought to pose the questions under. And many of the questions have come with sub-questions, and I've left it to the competence of our speakers to break up the questions and take them as something rounded and evolved so that they could answer it at one go. Each speaker would be just given about 3 to 4 minutes to address a whole bunch of questions. So if you don't get a full answer to the question that you have posed, you understand that it is because of time constraints. We are going to start off with Graham Leung, who has agreed to answer a group of questions coming from Malaysia, Fiji, and as far away, if I may say so, as and that falls within our Commonwealth jurisdiction, as far away as Antigua. And Graham has got those questions, and he will touch upon them very briefly as to what they are about and seek to answer them. Over to you, Graham. You need to
Sorry,
unmute.
can you hear me now? Yeah, sorry.
Yes, you need to
Thank you,
unmute.
Chair.
All right.
So the
Right.
first question was, can the court declare coups by the military to be unconstitutional? The short answer is yes. I cite by way of support for that proposition the cases of Chandrika Prasad, decided by the High Court of Fiji and affirmed by the Court of Appeal of Fiji, and Garase against Bainimarama, decision of the Court of Appeal of Fiji. So I don't have time, Chair, to elaborate on that, but that's the short answer to the question. The courts can declare coups by the military to be unconstitutional. What happens after that, and whether there's a reversion to the legitimate authority is an entirely different question. The second question I've been asked to answer is, there is a statement that a strong government which controls a large majority in parliament is always a better option than a strong opposition. And I'm asked to agree or disagree. I do not agree with the proposition which has been propounded. In my opinion, a strong government which has a huge majority can lead to oppression and a weakening of democracy. A strong opposition is better able to hold a sitting government accountable. And I think it's healthy to have a strong opposition to keep the government on its toes. The next set of questions is, coups are a sign of a weak democracy. To prevent this happening, is it legally correct to enact laws to make it an offense? I think in most of our Commonwealth countries, the commission of a coup is regarded as treasonous under the domestic laws of most countries. The history of most countries where coups have taken place generally demonstrates that democratic institutions have not been firmly embedded in the domestic legal framework. The population is generally inert and not sufficiently aware of their rights. It's also the case where unscrupulous politicians are bent on retaining power, and they have deliberately undermined those institutions for personal or political gain. So it's relatively easy to legislate and pass laws criminalizing the conduct of coups, but it's an entirely different matter enforcing those laws. The next question I was asked was in reference specifically to Article 131 sub Article 2 of the Constitution of Fiji. And the question was, is the Republic of Fiji military forces the fourth branch of government? Article 131 of the Constitution is an interesting section. It basically says, and I quote, "It shall be the overall responsibility of the Republic of Fiji military forces to ensure at all times the security, defense, and well-being of Fiji and of all Fijians." So the question was asked, does this mean that the army is the fourth branch of government? And my answer is an emphatic no. If you look at the context and the totality of the Fijian Constitution, in the first article of the Constitution, it speaks of democratic values that underpin the Constitution. It speaks of the rule of law, and it speaks of freedom. So Article 131 of the Constitution of Fiji must be read in the context of the Bill of Rights and the fact that Fiji says within the framework of the Constitution that it is a democratic state whose underlying values are committed to the rule of law. The other aspect that I want to say before moving on is that I see I've come to an end. So I think I better wind up by saying that the Fiji Constitution subscribes to a representative democracy, and in a representative democracy, political control of the military is rooted in civilian control and authority. I'm sorry, I don't have time to answer the last question. Thank you, Chair.
Thank you, Graham. We'll try to come back to that last question, if time permits. The next bunch of questions are being handled by Andrew, and they come from Australia, and they're largely about the exercise of government powers in the present crisis that is being faced by the whole world, actually, the COVID crisis, the pandemic, and government powers in relation to that. They come from Australia, and there's a question from New Zealand, which is quite separate, that Andrew has agreed to take on. And there's a reference from New Zealand to the new LTC legislation, and quote unquote, whether it allows the executive to control the judiciary, and the views on this. Andrew, can I pass this on to you?
Yes, certainly. And may I take the second question first? I don't claim to know a lot about the Land and Titles Court in Samoa, but having had a brief look at some of the writing up on this case, it seems to me that it can be understood in a more generic sense of creating additional courts in jurisdictions, and how this is brought about, and whether or not these separate courts are actually in some way, an undermining of the rule of law, partly because of the way the judges are appointed and things of that nature. And actually in Malaysia, we have a similar challenge because in two of our states, in the Borneo states of Sabah and Sarawak, there are native courts of some sort in operation. And then in all of Malaysia, there are separate Sharia courts as well. And so the question, that has occasionally been raised is whether or not these can be considered courts in the the most specific understanding of the word courts, because of the way in which the judges are appointed, and the question of whether or not they actually exercise the independence of the judiciary, whether or not they are fully fledged to deal with all matters. In the Samoan situation, for example, they are not constitutional courts, and in fact, there is some provision to allow them to ignore international human rights law by reference to specific Samoan custom and tradition. And so it also then raises questions about the universality of human rights that has been accepted by countries around the world. And so I think, I would just want to say that we have to look at how judges are appointed. In Malaysia, for example, we have a Judicial Appointments Commission, but this is only a commission that recommends appointments to the Prime Minister, who then recommends them to the King. And then the question is, are there ways in which the executive can alter that or ignore those recommendations for political or other purposes? So I think we have to look at how judges are appointed, and certainly if the executive has too much power to either amend or otherwise ignore the recommendations of an independent commission, then questions will be raised about the independence of the judiciary itself. Very quickly to the Australian, or the question from Australia, I'm not sure I can do justice to the question, save that I think in some jurisdictions, and again I speak of my own in Malaysia, we have pending before the courts challenges to, in this case, for example, the declaration of emergency, challenges to the order to not call or recall Parliament, which have been promulgated under the emergency ordinance of which I spoke earlier, and the question of whether that is actually legitimate, constitutional, and even whether or not some of these ouster clauses that oust the jurisdiction of the court are in themselves constitutional or not. So I think, if I may say, the jury is still out on the effects of whether or not the courts in the Commonwealth have been able to play an effective role as a arbiter of the rule of law as countries struggle to, on the one hand, deal with the pandemic, and then on the other hand are exposed to the temptation to use existing laws or interpretations of the Constitution to arrogate to themselves extra constitutional powers. So that I'll leave it at that. Thank you.
Thank you, Andrew. I'll move on now to Professor Malaysia. There is a question specifically on Myanmar, and it comes, of course, from Myanmar. And a like question on the Myanmar situation has been posed by a participant from Japan. These questions have already been sent to Professor Melissa Crouch. Could I invite you, Melissa, to address these questions?
Thank you. Yeah, so I'm just going to sort of, I think, group them in two. So one of the questions was around whether the 2008 Constitution does provide a way out of the coup and back to civilian rule or semi-civilian rule. And the other question was around the emergence of different interest groups at this time and how they can work to build a common goal, and particularly how to manage the challenge between ethnic armed groups who disagree with the elected representatives who want to return to the previous system. So just on the first one, on one hand, of course, the military is saying that it is still following the 2008 Constitution, and in some situations, a state of emergency would allow for a new election to be held. However, because the state of emergency is not constitutional in itself, I think that can be disputed. But obviously the 2008 Constitution does potentially allow for elected members of parliament, so the incoming government, to form office if their term hasn't expired. So their term is for 5 years. If this coup only lasts for a year, it's possible. One way is to, try to negotiate for the military to return power to allow the incoming government to sit for the remainder of their term, so for 4 years. Of course, ethnic armed groups in particular don't agree with the 2008 Constitution itself, and others also have significant disagreements. In terms of, the various actors we've seen involved, the civil disobedience movement, Generation Z, and then there's a range of other organizations. I think in coming days and weeks, we'll be watching to see if they are able to work towards a common goal. I think that's quite difficult, but one thing that might be possible at a sort of broader level is if it was possible, and I think it's quite difficult, but if it was possible for the elected representatives to have power transferred back to them, is to perhaps negotiate to hold a referendum. And the referendum could be on something as simple as, should we draft a new constitution, yes or no? And that kind of a referendum might then give a legitimate mandate to the elected government to then consider redesigning a new system. Because I think in the absence of that, if the demands are, that the military should both return power to elected civilians and allow them to change the constitution, that's difficult to argue. But if you can find a way to get the endorsement of the people for that action, for example, through a referendum of the people, that perhaps might be one way to endorse that. But I acknowledge that the severe difficulties of the situation, and acknowledge that for many people, the 2008 Constitution has always been a document that lacked legitimacy and credibility precisely because it was drafted by the military. Thank you.
Thank you, Melissa. There have been a couple of online questions that have come on Myanmar. My people here are trying to put that together, and we'll probably get back and get it on to you once we have worked it out. But let me move on. And we have got a set of questions here from the Emirates. and dealing with the issue of misuse of institutions and breakdown of governments, Dr. Jayampathy has agreed to take on these questions. And along with this group of questions, there's also a related question from Nepal on the differentiation between constitutional breakdowns and coups. And Dr. Jayampathy has kindly agreed to deal with this bunch of questions. Could I pass the floor on to him, please?
Yeah, on the second issue, constitutional breakdown, there is a crisis arising out of the failure of a constitution to perform its central function. The constitution may be clear, but still the crisis arises out of a failure. Politically, when it is politically infeasible to follow it, and the government institutions themselves fail to live up to that, what the law prescribes. We had the example of Belgium in 2010, where Belgium, there is a requirement, Article 99 of the Belgian Constitution, which says that there should be, apart from the Prime Minister, equal numbers of Dutch-speaking and French-speaking ministers. Now, that could not be achieved, and Belgium went for 541 days without a government. But then the constitution did survive, and they found a way out. But the danger is that in the guise of constitutional maturity being broken down, that extra constitutional means are tried. This happened, famous example in Pakistan. There was a question also on Pakistan. In 1954, when the Governor General dismissed the Constituent Assembly, claiming that the constitutional machinery had broken down. Actually, what happened was that the new constitution that was to come was to take much of the powers away from the Governor General. And then, of course, what was unfortunate is that the courts found a way out to help the Governor General to survive. Later also invoking the doctrine of necessity. And in 1955 itself, the Governor General himself was deposed by another army personality, I think Mirza, and later he annulled the constitution. That was also okayed by the Supreme Court, the infamous judgment by Munir, Chief Justice Munir, who said, now that the revolution has been successful, it satisfies the test of efficacy. Now in Pakistan, you had this doctrine of necessity being invoked, and then of course going back and say, no, you can't do it. In Asma Jilani's case in 1972, the Supreme Court said, no, you can't. But then again in 1977, in the Bhutto case, again said, no, you can. But finally in 2019, I don't know whether it's finally, but 2019, the Supreme Court said in the famous Prime Minister's case, Gilani's case, that the doctrine has been buried. I hope the doctrine of necessity has been buried and it will stay buried. One does not know. The other issue is, of course, oppression by the majority, for which there are some difficult questions for which there are no clear answers, easy answers rather. When the independent institutions themselves come under pressure from an oppressive majority, the judiciary comes under pressure, the election commission comes under pressure, and even the media, even the private media come under pressure. That is a completely different situation. In Sri Lanka, we were able to survive because the independent institutions had survived, were intact. But when all those institutions also break down, then of course, it's a very difficult situation for which there is no answer through the Constitution. Thank you.
Thank you very much, Dr. Jayampathy, and thank you for reminding us of the corpus of case law from Pakistan on this subject, because you take the Pakistan case law and the case law from your jurisdiction and that from Fiji, you have got this whole body of case law that has dealt with this area of coups and emergencies and constitutional breakdowns in government. And I think Professor John Hatchet has actually authored a book for the Commonwealth Secretariat on, what's it called, John? Well, I think he's unmuted.
It's a very good
Sorry.
question. I don't have it with me.
Yes.
I'll circulate it if it's undermining constitutions or something like that.
So how to handle constitutional breakdowns within the Commonwealth? Something along
like
those
that.
lines.
Yeah.
So,
It goes through the whole of the Commonwealth jurisprudence. Most of them are moved on those. Yeah.
right. Well, just as well, because the next set of questions are to be handled by you. And
Right.
these come from Malaysia. And the questions posed are broadly on multilateral grievance procedures. And Professor John was asked to look at them overnight and get to what really is the thrust of the question that is being posed. Could I get you to respond, please?
Yes, I mean, I think one of the important background issues here is that there's been a change in the international environment, that there's been, I think, a recognition that protecting constitutions has become more and more important. So just to mention a couple of mediation approaches. One of them is the Commonwealth Ministerial Action Group, CMAG, which engages proactively with countries, not simply where there's been a coup, but where there have been issues concerning the recognition of the Commonwealth fundamental political values. And this is the issue of just and honest government, which I think is sort of the bedrock, of course, of everything that the Commonwealth does. So that's one mechanism. Other mechanisms, another example would be from the African Union. Now, up to relatively recently, the African Union took no interest in coups, but more recently they have been much more proactive. They threaten sanctions against countries, Burkina Faso being an example. And in the case of Mali, in August 2020, they also entered into negotiations with the military to find a constitutional way out. So I think there are mediation mechanisms, not necessarily to resolve, but to help resolve these constitutional breakdowns. I would also just add that one of the issues, of course, leading to constitutional breakdowns, and this was mentioned by Melissa as regards Myanmar, is the problem of free and fair elections or electoral fraud. And I would just mention that there have been a number of cases in the Commonwealth where there have been successful constitutional challenges to elections, for example, in Kenya. So I think the courts and the lawyers in the Commonwealth can do a great service by actually looking at the way in which they could protect the Constitution, for example, in this way. Finally, the questioner asked whose interests should be considered when seeking to resolve constitutional breakdown. I would like to change it to what interests should be considered. And to me, I come back to the Commonwealth fundamental principles. The interest that should be considered is the need to retain and build on just and honest government. There's a range of issues, for example, the Latimer House Guidelines, which sets out effective relationships between the three branches of government. And so I think it's beholden to everybody to recognize that if we go along the line of just and honest government being the cornerstone of the Constitution, the constitutional process, then I think a lot of the issues that we've discussed can be looked at in a much more positive way. Thank you, Chair.
Thank you very much, John. Thank you for reminding us of the Latimer House guidelines in which you were involved, and I think I was also involved almost 10 years ago, and that has actually been well received by CMAC as well. I'm going to go back to Graham Leon to answer the question from Antigua, but before that, could I just confirm with Professor Melissa if she has received the online question that has come on? It's a pretty long question, and we were having some difficulty deciphering it, but if you have worked it out, you would understand it better. So
Sure.
I'll come to you very shortly, but
Okay.
let me get Graham to respond to the Antigua question. Graham?
Yes, thank you, Chair. The Antigua question, Chair, was if a court is impliedly suspended along with the Constitution, who or how efficacious can the issuance of declaratory statements be? And I think, just to repeat an answer that I gave in my presentation, effectively, the courts would be powerless in the face of issuing declaratory judgments if the authorities or the usurpers refuse to follow. Of course, a declaration, to state what is obvious, is it's a piece of paper, it is not self-executing, and the judicial system in all our countries is predicated on the assumption that litigants and the state will follow orders of the court. And where there is defiance of the court's injunctions and orders, I think you're looking at a state which is in deep trouble. It means that the rule of law is being undermined, democratic institutions are being undermined, the separation of powers is being undermined. And a functioning judiciary is essential, more so in times of crisis and instability. The other question related to this is where the crisis extends indefinitely and the rule of law is compromised with legitimacy, what then? And my simple answer, Chair, is if the situation is not managed and the authorities do not comply with orders of the courts, it can lead to a breakdown of law and order and anarchy, and the whole situation becomes unworkable and uncontrollable. So we need to have independent and functioning courts, and the authorities, including military usurpers, need to understand that they are subservient to the Constitution and are bound by decisions of the courts. I thank you, Chair.
Well stated, Graham.
Are you happy for me to go now?
Right. I was just saying, well stated, Graham, well stated. And would I now move on to Professor Melissa Crouch? I think you must have understood the question.
Yes.
It's a rather long one as written out here for us. Could I leave it with you, please?
Yes, I think part of it was a comment, but I think the overall question was about whether ethnic armed groups in Myanmar could potentially replace the role of the military. So in Myanmar, there are a large number of different ethnic groups. There are some that have armed groups that are still fighting against the government. And I guess the question is around what role would they play post-coup? I think more broadly, it comes back to the peace process and the national ceasefire agreement. So prior to the coup, there was a peace process. There was a national ceasefire agreement. We're not quite sure at this stage what the status of that is, although from the military's perspective, they have reconstituted a peace council. I think any solution going forward needs to keep the peace process in mind and to be mindful of what role ethnic armed organizations might play in the future of Myanmar. I'll leave it there since I know we're almost out of time.
Thank you very much. You were able to see the acronyms that were used there. We couldn't understand it, and my colleague here was trying to get onto Google to find out what the acronyms were, but you knew what it was. All right, we have got 5 minutes, and There is a very broad question here, which is addressed to Professor John Hatchet. It has come online, but I'm going to get both John and Dr. Jayampathy to look at this. Let me just read the question as it has come across. It reads as follows, very broad, quote unquote, how to ensure that constitutions are not undermined by unconstitutional means. That's your book. So could I invite Professor John Hatchet first and Dr. Jayampathy, with your experience, recent experience, not too long ago, you would be also able to give us your input. Over to you, John.
It is a very broad question, and I replied to the questioner by suggesting that that they contacted me via email, and I can have a full discussion with them. And I would leave that as a general invitation to any participants who want to raise that with me to email me, and we can have a discussion. I've written a lot of material on that, as you mentioned, and again, I'm happy to share that with everyone. In terms of time, I don't want to sort of start discussing what should be there. Simply, perhaps to emphasise, as others have emphasised, that to me, the Constitution is the supreme law. And as the supreme law, everybody is under the Constitution. And if there is a public and a very public acceptance of the Constitution and its provisions, then that is the bedrock. And South Africa, I think, is a perfect example of a situation where, from a state of absolute chaos constitutionally, they developed a constitution that is one which is meaningful to everyone. And it's that, I think, that we need to be striving for at all times, the supremacy of a constitution that enjoys the support of everyone in society. I'll leave it there.
Yes, well, as Graham in his main speech told us, he gave us a quote from Justice Gates in the Chandrika Prasad case at first instance, that man should not unmake a constitution. Could I pass it on to Dr. Jayampathy now?
I think that's a very difficult question. I find it very difficult to answer that question, because I mean, you go on the basis that there are institutions which have the power to strike down any unconstitutional move on the part of any person. And but when the whole order changes, the whole order is challenged, and for example, the Supreme Courts, even the Supreme Court, the Election Commission, their authority is also undermined by unconstitutional means. What do you do? Right? I mean, in the Sri Lankan case, we were lucky. The Supreme Court was there to safeguard us. But if the Supreme Court's independence had been undermined, parallel to what happened in Parliament, in the dissolution of Parliament, we wouldn't have, I mean, I dread to think what would have happened. I really don't have an answer. It's such a difficult issue. Because there is no world court, right? For example, there is no transnational authority to decide these things. They have to be decided in the domestic sphere. And in the domestic sphere, when such independent institutions are undermined, there is no way out. It has to be.
I'm afraid, yes, I agree. I agree. I'm sorry to come in. I agree with you, Dr. Jayampathy. We are again having another very broad question here, which actually goes back to what you and John had just handled, but it has come on, and I think I need to put this across. And anyone who thinks that he or she is able to answer this could come on. Question reads as follows: what pragmatic solutions can be used to resolve the entrenched positions of opposite parties in a coup or in a constitutional breakdown situation? Very broad question. I repeat, quote unquote, what pragmatic solutions can be used to help resolve the entrenched positions of opposite parties in a coup and constitutional breakdown situations? It comes from my jurisdiction. All right. As a start off, Andrew, have you comprehended that?
Yes, I have. But
Yes.
I think Graham has already answered that question.
Yes. Yes.
In a reply directly to Jeff Leong. But basically, he talked about, if I may just repeat his answer, talking about a respected international statesman who might come to play the role of an honest broker or mediator to someone that both sides or the different sides of the conflict would respect. So, in some ways, maybe an individual, or as we referred to, CMAC to be able to come in and to play that role, but merely as mediators rather than adjudicators of the conflict.
Yes, I'm glad you mentioned about CMAC. John, how efficient has CMAC been within the Commonwealth? We have had a number of coup situations in the Commonwealth. Your book deals with that. But has CMAC been helpful or successful?
No, I think CMAC has been very helpful in many ways, but one has to remember that it is up to the individual states to decide whether or not it will accept CMAC's assistance. And of course, in the case of Fiji and also Zimbabwe, where the state doesn't like what CMAC is saying, they withdraw from the Commonwealth. But I do think that sharing experiences, and CMAC, of course, is made up of experienced ministers and others from around the Commonwealth who can understand and have experience of these types of constitutional crises. And I think it's that sort of mediation that has proved helpful. Whether it has actually resolved issues is another matter, but I think they played an important role in at least allowing opposite parties, governments, etc., to actually sit down with independent individuals who are knowledgeable about the issues to try to resolve some of these questions. So I think that those who haven't heard of the Commonwealth Ministerial Action Group, it's very worthwhile looking at their work.
Yes, it's called the Commonwealth Ministerial Action Group. Well, ladies and gentlemen, all participants out there, we are time overrun by 5 minutes, but we have otherwise done excellently well. May I, on your behalf, wind up this very successful webinar? And may I say this, that I'm very happy indeed to have reacquainted myself with many of my old friends who are on the faculty of speakers, and equally happy to have met new ones. And may I, on your behalf, congratulate each and every speaker for their strong sense of discipline in keeping time and dealing with very difficult subjects in a very succinct and clear manner. And I think on your behalf, you will agree with me, if we were physically present here, we will be able to give them all a very loud round of applause, which unfortunately we're not able to. But on your behalf, I congratulate and thank each of the speakers. And may I also thank all of you participants out there, more than 200 of you. I think the last number was about 216. And thank you very much for your active participation. Thank you for all those who sent those pre-submitted questions. Thank you for those who have been sending questions online as this webinar moved on. Thank you very much. And as you know, this is the third in a full series webinar. And the next webinar is being held on the next Thursday. And if you look at the website, you'll see the details of that webinar. May I, on behalf of the 4 law associations, that is the Commonwealth Lawyers Association, the Law Council of Australia, Law Asia, and the South Pacific Lawyers Association, may I, on behalf of all these very distinguished law bodies, invite you to participate at the next webinar series. Thank you very much. I'm signing off. Thank you again to our very distinguished faculty of speakers, and thank you very much for the very brilliant submissions made by all of them. Thank you very much. Bye.
Bye.